Welcome to the second part of our look at the sole responsibility rule under the immigration rules. So as we were talking, this rule is especially relevant for somebody who's in the United Kingdom and wants to bring their child to join them in the United Kingdom. So what I want to do today is just look at the actual immigration rules themselves and see how they're constructed and how the sole responsibility issue comes into play vis-a-vis the rules. So the rule normally when you want to bring a child into the UK is paragraph 2971 of the immigration rules. And that 2971 is broken down into various grounds where you can bring a child in, numbered A to F. Ground A is where the child is seeking to enter, to accompany or join a parent or parents or relative in one of the following circumstances. So A, both parents are present and settled in the United Kingdom. So if both parents are here, then it's not an issue of having to prove responsibility because both parents are already in the United Kingdom. B, both parents are being admitted at the same time. So again, that's very similar to A. C, one parent is present and settled in the United Kingdom and the other parent is being admitted at the same time as the child. So slightly different, but again, you can see A, B, C, all to do with both parents being involved, and therefore there's no mention of sole responsibility. D, one parent is present and settled in the United Kingdom and the other parent is dead. So, I mean, that speaks for itself. You have sole responsibility if the other parent is dead. That's very clear cut. But it's a very drastic thing to have to show. And very few circumstances would use that paragraph. And then paragraph E is the circumstance where it says one parent is present and settled in the United Kingdom or being admitted at the same occasion and has sole responsibility for the child's upbringing. So this is where the sole responsibility requirement raises its head. And there are many, many cases where this is going to be the paragraph that has to be used because the other paragraphs either require the other parent to be coming to the UK or already in the UK or dead. So this is the first one that deals with the circumstance where it's only one parent in the UK and the other parent is not necessarily emigrating for whatever reason, be it divorce, separation, abandonment, many different issues, but this is what the sole responsibility issue is here to deal with, these type of situations. There is a further paragraph, paragraph F, where one parent or relative is present and settled in the United Kingdom or being admitted on the same occasion, and there are serious and compelling family or other considerations which make exclusion of the child undesirable and suitable arrangements have been made for the child's care. So that's quite a long paragraph, and as you can see there are a number of different issues that are brought into play, whereas paragraph E just requires sole responsibility. Paragraph F, although it does not require sole responsibility, brings other requirements in, and potentially that could be just as hard to prove and rarer to prove than the sole responsibility. So you can see that the rules are not really designed to cope with single parent families where potentially there is some involvement from the other parent. It seems to want to exclude the involvement from the other parent in order to qualify the child for entry clearance. And this is why this issue is so prevalent in immigration circles, because time and time again it ends up in front of the tribunal because it gets refused on this issue.